This event is a collaboration of OC Diversity Task Force, OC Lavender Bar Association, and Knobbe Martens. We're very excited to have everyone here. My name is Charlene Azima. I'm an associate here at Knobbe and also a representative of the OC Diversity Task Force. The Diversity Task Force is a collaboration of law firms and members of the community to promote diversity among lawyers in Orange County. And I'm going to introduce Jeff Van Hoosier, who's a partner here at Knobbe Martens, and he's going to introduce our speakers today.
Good afternoon, everyone. Welcome, and thanks very much for being here. On behalf of the Orange County Diversity Task Force and the Orange County Lavender Bar Association, it is truly my pleasure today to introduce our two speakers. We have Jenny Pizer. Jenny Pizer is the Senior Counsel and Director of the Law and Policy Project for Lambda Legal. Hopefully all of you know that Lambda Legal is the nation's leading advocate for the LGBT civil rights movement. She previously directed the Lambda Legal's Marriage Project. She's been very instrumental in pretty much everything that's happened as far as marriage rights in regard to us. Prior to being there with Lambda Legal, she also was the legal director of the Williams Institute at the UCLA School of Law. And Jenny is a graduate of the NYU School of Law and of Harvard Radcliffe College. We also are pleased to welcome today Dean Chemerinsky. Dean Chemerinsky is at the University of California Irvine School of Law. He's the founding dean and a distinguished professor of law there. Prior to being here at UCI, he was at Duke University for several years and also taught at University of Southern California School of Law, or it looks like 21 years, according to that, his biography. Prolific author, he's written 7 books. The most recent book, which many of you may know, is The Conservative Assault on the Constitution. Dean Chemerinsky holds a law degree from Harvard Law School and his bachelor's degree from Northwestern University. If you would, please give a round welcome to our two speakers today.
It's such an honor and pleasure to be here, and it's always wonderful to get to a panel with Jenny. She's one of my heroes. What we thought we would do is talk first about what the Supreme Court held in the 2 cases on Wednesday, June 26th. Then Jenny would talk some about what's happened in the litigation since June 26th, 2013. And then each of us would offer some thoughts about what this is likely to mean for the profession in future litigation. My guess is that by this point in time, everyone is familiar with what the Supreme Court did and didn't do in United States versus Windsor and Holdingsworth versus Perry. So let me just quickly go through them and also identify some of the many questions that are left unresolved. In 1963, Edith Windsor and Thea Spire met. They began living together in 1967. They lived together in an apartment in Manhattan. They also came to own a house together in Long Island. They lived together until Spire passed away in 2009. In 2007, they went to Canada and they got married. In 2011, the New York legislature passed a law to allow and recognize same-sex marriage. Under the New York law, their marriage would be recognized even though it occurred before the statute was adopted. In 2009, Spire passed away. She had a will that left all of her assets to her spouse, Edith Windsor. If federal law recognized their marriage, then Spire's estate would owe no estate taxes. But Section 3 of the Federal Defense of Marriage Act said that for purposes of federal law, marriage had to be between a man and a woman. Because of Section 3 of the Defense of Marriage Act, federal law would not recognize their marriage. Windsor paid $363,000 in estate taxes. She then brought a constitutional challenge to Section 3 of the Defense of Marriage Act. The federal district court ruled in her favor. The Second Circuit affirmed. And on Wednesday, June 26th, the Supreme Court, in a 5-4 decision, affirmed the Second Circuit. There were some complicated standing and jurisdictional questions owing to the fact that the United States government also agreed with her that Section 3 of the Defense of Marriage Act was unconstitutional, and it was the bipartisan leadership group from the House of Representatives that intervened to defend Section 3 of the Defense of Marriage Act before the Supreme Court. For our purposes, we want to focus on the merits. Justice Kennedy wrote for the court, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Chief Justice Roberts, Justice Scalia, and Justice Alito each wrote dissenting opinions. Justice Thomas joined them. Justice Kennedy began by saying that marriage has traditionally been defined and regulated at the state level. He said New York would give, quote, dignity and respect to the marriage of Windsor and Spire. He said there has to be a good reason for the federal government to refuse to do so. He said there wasn't a good reason behind the Defense of Marriage Act. He said it was based on a desire to disadvantage gays and lesbians. He quoted the legislative history of the Defense of Marriage Act, which expressed that the goal was to express moral condemnation of homosexual activity and support for traditional heterosexual marriage. He said this is not a legitimate purpose sufficient to meet the requirements of equal protection. If you're familiar with Anthony Kennedy's jurisprudence over the more than quarter century in the court, there are many things in this opinion that are familiar. So, for example, Justice Kennedy has long emphasized states' rights and federalism. That's found in this opinion. Prior to this case, there were only a couple Supreme Court decisions that expanded the rights of gays and lesbians. Romer v. Evans in 1996, Lawrence v. Texas in 2003. In both of those cases as well, the majority opinion was written by Anthony Kennedy. What's interesting is in none of these cases did Justice Kennedy express a view as to the level of scrutiny that was being applied. In Romer, it seems the court was using rational basis, but there's certainly a strong argument the court is doing much more than that. In Lawrence, the court pointedly didn't say the level of scrutiny. And in Windsor, again, the court didn't say the level of scrutiny that was applied. In insert here, you might have seen that yesterday, the Ninth Circuit in SmithKline versus Abbott Laboratories said that Windsor implicitly was using heightened scrutiny. The Ninth Circuit said heightened scrutiny is to be used for sexual orientation discrimination. And the Ninth Circuit therefore said, on that basis, that peremptory challenges can't be used for sexual orientation, just like they can't be used on the basis of race. I like what the Ninth Circuit read into Justice Kennedy's opinion, but he doesn't say what level of scrutiny that's being used. Chief Justice Roberts, in his dissent, stressed that all the court was doing was striking down Section 3 of the Defense of Marriage Act. It was not expressing any views on the state laws that prohibit marriage equality. Justice Scalia, in his more angry dissenting opinion, said there's no way to distinguish between what the Supreme Court has said about Section 3 of the Defense of Marriage Act and it will say about state laws when those are challenged. His exact words was, it's just a matter of waiting for the other shoe to drop. He took passages of Justice Kennedy's majority opinion, crossed out Section 3 of the Defense of Marriage Act, inserted state law, and said, see, the result would be the same. Justice Alito also wrote a very angry dissent, and he said, marriage has long been defined as being between a man and a woman. The federal government should be able to do that. The other case decided that day was Hollingsworth versus Perry. As everyone knows, in May of 2008, the California Supreme Court interpreted the California Constitution to create a right of marriage equality for gays and lesbians, a case brought by Lambda and argued by Jenny's colleague, John Davidson. In November of 2008, California voters passed an initiative, Prop 8, to amend the state constitution to effectively overturn that decision to say that marriage had to be between a man and a woman. Two same-sex couples who wanted marriage licenses brought a challenge to Prop 8 in federal district court in San Francisco. The judge held a trial. At the end of the trial, the judge, Vaughn Walker, declared Prop 8 unconstitutional as denying equal protection and infringing the fundamental right to marry for gays and lesbians. Judge Walker issued an injunction against the defendants, the governor, the attorney general, the state register of records, all under the direction and control, from enforcing Prop 8 anywhere in California. The defendants promptly said that they were not going to appeal Judge Walker's ruling. The supporters of the initiative, Protect Marriage, said it wanted to appeal. After briefing and oral arguments, the Ninth Circuit certified to the California Supreme Court the question whether the supporters of the initiative be able to represent the interests of the state when the government officials were not doing so in defending an initiative. The California Supreme Court ruled unanimously that the supporters of the initiative could represent the interests of the state. In February 2012, the Ninth Circuit then said the supporters of the initiative had standing to appeal, but the Ninth Circuit on the merits found that Prop 8 violated equal protection. On June 26, the Supreme Court, in a 5-4 decision, vacated the Ninth Circuit's opinion. Chief Justice Roberts wrote, joined by Justice Scalia, Justice Ginsburg, Justice Breyer, and Justice Kagan. Chief Justice Roberts said, in order for a party to have standing to appeal, the party has to show that it personally has been injured. Court said that Protect Marriage has no injury other than an ideological one in wanting to see Prop 8 upheld in the courts. The court said an ideological injury has long been found to be insufficient for standing. Therefore, the supporters of the initiative do not have standing to be able to appeal. The effect is that the Ninth Circuit decision is then vacated. But of course, the two same-sex couples who wanted marriage licenses had standing to bring their challenge in federal district court. The district court decision then remains in place. Protect Marriage went to Justice Kennedy after the Ninth Circuit had lifted the stay of Judge Walker's order on June 28th and asked him to put a stay back into place to keep Prop 8 from going into effect. On Sunday, June 30th, Justice Kennedy refused. Protect Marriage then went to the California Supreme Court. They asked for an emergency order that Judge Walker's ruling applied only to these two couples and only to two counties named in the lawsuit. And they appealed on that basis. The county clerk of San Diego asked the California Supreme Court for an emergency order that he didn't have to issue marriage license to same-sex couples. The California Supreme Court denied the emergency relief and then dismissed the appeal. So since Friday, June 28th, same-sex couples have been able to marry in California. And until and unless the federal district court wants to modify that order, that's the law of California. Now, these cases leave so many questions open. What is the level of scrutiny that's to be used for sexual orientation discrimination? Said yesterday, the Ninth Circuit said it's heightened scrutiny. And we need to see what the Supreme Court does. Well, how is marriage to be defined? Is marriage based on where it's celebrated or where the couple lives? Imagine a couple from Texas goes to New Mexico, where same-sex marriage is now allowed, and they get married and then they move back to Texas. Are they deemed married because they celebrated a marriage in New Mexico? Or not married because they live in Texas that doesn't recognize same-sex marriage? What if they filed for divorce in Texas? The Texas Supreme Court had oral arguments in two cases in November as to whether Texas had to allow same-sex couples to divorce even if they couldn't marry. What about evidence questions? What if that same-sex couple in Texas is involved in litigation in federal court and state court, and an issue comes up as to whether they can claim spousal privilege, something traditionally decided by state law? Are they entitled to spousal privilege? What about Section 2 of the Defense of Marriage Act? It says that for purposes, it says that no state has to recognize a same-sex marriage from another state. If the Defense of Marriage Act serves no legitimate purpose, then could Section 2 of the Defense of Marriage Act be constitutional? A federal district court in Cincinnati has declared Section 2 unconstitutional and said that Ohio must recognize a same-sex marriage from another state, even though Ohio has a constitutional amendment that says in that state marriage has to be between a man and a woman. And what about the laws in 33 states that still prohibit same-sex marriage? There are challenges to these laws pending all over the country. And so to talk about what's gone on since June 26th, turn it to Jenny.
So I think you can all see, and you probably all know because you have the great delight of having Dean Chemerinsky here just as your neighbor. He is one of the leaders of constitutional thought in this country, and we talk about heroes. I just want to say what an honor it is and what a great benefit it is for those of us who are engaged in cause lawyering to have one of the most brilliant minds in the country interested in these issues and also focused on the role of having public conversation about the Constitution and what it should mean and why we should all care, done in a way that everybody can understand by putting energy into not just writing textbooks for lucky law students, even if they don't think they're lucky at the time they are, but in the major papers to make these ideas lively and relevant and accessible for our whole country so that our constitutional conversation can move in productive directions. So, boy, are we lucky to have him here. So what a year and what a moment we are having in the movement for lesbian, gay, bisexual, and transgender equality in this country. I want to say I've had the honor of working on lots of things, as Jeff indicated in my bio, and generally as part of a team of people working very hard, including an enormous number of people in private practice who are interested and want to do some things that are kind of exciting and different, and sometimes have a chance to exercise some litigation skills or some deal with even some procedural questions that don't always come up in the usual business line of work. As I'm sitting here, I'm struck to realize that when I was in private practice, I actually frequently worked with Knobbe lawyers because I used to practice intellectual property litigation, and when I realized it was almost 20 years ago, it's a little breathtaking. But it's really great to be talking about these issues here in Orange County and with all of you, even if many of you are here because you need your elimination of bias credit. The timing is felicitous. Gosh, there's a lot going on. Because this is an elimination of bias program, we are going to be talking specifically some in a couple of minutes about the ways that these legal changes have direct effect on law firms as employers and on probably some of your clients in their role as employers, but also in terms of, so not just in terms of the Federal Defense of Marriage Act statute has been struck down, and so that affects various federal rights, federal employee rights and tax rules and so forth, but also the effects that this is having on the legal community, the climate expectations that people have, that employees and employers have, and also what I imagine many of you deal with in terms of aiming to recruit young lawyers and attract clients who may care about these issues and want to see, diversity and inclusive practices in law firms. Because we're not. This is not a 5-hour program. We're going to be touching on various things, but I do want to invite you to look at the materials that were passed out. We won't go over all the things, and in particular, there are fact sheets here looking at a lot of the issues that are maybe not quite so relevant to law firms as employers. For example, TANF, temporary aid to needy families, not something most commercial law firms deal with, but the issues might come up. So there's lots of information here that we won't touch on today, and I invite you to have a look. And keep in mind that these fact sheets are to give a focus on the particular issue that is changing, or issues that are changing because DOMA has been stricken, but also to give a couple little hooks into the field of law, because most of us don't practice in all of these. Really, nobody practices in all of these. And so for some of us who haven't thought about these issues before, it's a little primer to get you into it. And I want to credit not just my colleagues at Lambda Legal who put a lot of work into these. I did some, but there were actually a number of major law firms, specifically folks in New York and D.C., who partnered with Lambda Legal, the ACLU, National Center for Lesbian Rights, Gay and Lesbian Advocates and Defenders. For those of you who aren't familiar with the legal work in this movement, there's actually lots of us in different parts of the country working on these things. So it's a pretty tremendous effort to make this information accessible, at least in an open the door kind of a way, because a lot of these issues have just not been relevant to same-sex couples before, and the main thing we want to do is to flag for people the key rule that Erwin just mentioned, which is that up to this point, so we had DOMA saying that married same-sex couples were just not married for federal purposes, and many people who were married under state law, especially in California, where we had estimate at least 18,000 couples who did get married before Prop 8 passed, having a state legal status that was inconsistent with the federal status. So now that DOMA has been stricken, life is now simpler. I'll speak as somebody for whom that's true. Our tax situation was kind of confusing for a couple of years in there, having to do state taxes one way, state income taxes one way, federal income taxes another way. I think it made some of the tax preparers a little wealthier, although they complained enough that, I'm not sure maybe they were just putting that on. But now that DOMA has been stricken, we have, in a sense, flipped the situation over. And with respect to taxes and some other issues, we now have couples who got legally married in some state, and they're living in a state that doesn't respect the marriage. And so you will probably have maybe colleagues, those of you who are with firms that have offices in multiple states, colleagues, clients, people that you know, people that will ask you questions. You're a lawyer, you should know the answer, no matter what the field is. That situation in a number of states is now flipped, and people will be treating their federal taxes one way, and their state taxes will remain the same. And so life has gotten simpler for people in some states and more complicated in other states. And we'll touch on some of those issues. Before doing that, I want to give just a little bit of detail of how the landscape has shifted since the decisions came down in June, to give you mostly a sense of that there's an awful lot of moving pieces, and some of us spend a lot of our time sort of filling in charts of how many new cases have been filed and where are they filed and how many of them new cases that are being filed in the Fourth Circuit, and do we have any yet in the Seventh Circuit. It's really a lot to keep track of, and I think there is a general recognition among pretty much everybody that this is all a crescendo leading up to the next time the Supreme Court is asked, the question that was asked in the Perry case, was asked in the Prop 8 case, whether the Equal Protection Clause requires not just equal treatment of already married couples by the federal government, but similar dignity, equality, inclusion by state governments in the same way that, the famous case, Loving versus Virginia, said for laws restricting or prohibiting interracial marriage. So where we are right now is the rule had been for federal purposes that with respect to most things, that you would be considered married if your state of domicile considered you married, regardless of whether you married legally someplace else. The Obama administration has done an awful lot of legal analysis, the Department of Justice, and has come to the same conclusion with respect to most things, the same conclusion that some of us had recommended, that that's not been required in federal law. That generally speaking, that was a rule that seemed convenient, that was adopted by policy and practice and occasionally by regulation. But actually, for most purposes, it's just as reasonable for the federal government, for federal purposes, to consider the place of celebration rule. And so what that means, and you'll see, this is sort of an update to these sheets, that since June and since the publication of these sheets, the administration has concluded that the place of celebration is going to be the rule for most things. The one I want to highlight that's still sort of percolating is for Family Medical Leave Act. There's a federal regulation issued by the Department of Labor that says it's the domicile rule, the place of residence. And so that's an exception. I didn't want to, if we run short of time, I didn't want to forget to mention that. But with respect to most of the sheets here, we now know it's going to be the place of celebration rule. And what that means is that the federal government is setting an expectation that I think affects the climate for businesses, for employers, especially for businesses that work interstate, and for couples, that the federal government is treating married people as married, and so should other people. And so it's putting some pressure on states where state law, because of a statute or in most places because of a constitutional amendment, says that the state will not recognize those marriages, won't allow same-sex couples to marry, and won't recognize their marriages from out of state. And that is something that I think many of us as lawyers, we are well suited if we prepare to engage in conversations with people about that, because, as I said, sort of the pressure has flipped, and life is now considerably more complicated, not just for couples, but for employers, and in some cases for local government, if the state is insisting on not recognizing marriages where the federal government is and couples' expectation is. So here's a few factoids about the patchwork or the checkerboard or whatever we want to call what our map looks like now. As Erwin mentioned, there's an awful lot of lawsuits going on right now. It's one of these kind of switches. When I started working in this field, we sometimes thought about the cootie effect of, work on gay and lesbian civil rights, and many firms did not want to work on these issues, and now the phone rings off the hook of people who think it's exciting and interesting, which it certainly is. And in part because lots of lawyers are interested, we now have at least 45 marriage cases going on, 27 of them in federal court, and 18 of them in state court. A number of those state court cases, though, have federal claims, which means that any of those cases, and we have that in particular in Texas, where we're anticipating rulings from the Texas Supreme Court. If the Texas Supreme Court says, no, the Texas constitutional amendment is sound, no equality problem here, those cases could be appealed to the U.S. Supreme Court because they have federal claims. These 45 suits are tackling the laws of 24 states, and they really do span the country as a whole, from Arizona and Arkansas to Virginia and West Virginia and pretty much all the states in between. The leading case, or the case that has been sort of ahead to be next in the queue to be decided potentially by the Supreme Court, is a case against the state of Nevada that Lambda Legal is doing. Sevic against Sandoval came out of Nevada, and that the briefing there is underway. There's yet, I think it was a more than 100-page opposition brief just filed by the state, and my colleagues will be doing our reply brief relatively soon. So that has been out in front. However, there's been lots of activity in the 10th Circuit. Folks, I'm sure, noticed that right around Christmas time we saw same-sex couples getting married in the shadow of the Mormon Tabernacle Choir or I shouldn't say in the shadow of the choir, I should say perhaps with the backing of the choir in Salt Lake City. The Herbert versus Kitchen case, very exciting. We think over 1,000 couples got married, and that case is now in front of the 10th Circuit, the Supreme Court having issued a stay. So no more marriages, but there's an awful lot of married couples now in the state of Utah. And there's actually been, that's a federal case, a state case filed there by the ACLU on behalf of married couples who are validly married under Utah law and would like the state to honor them, and the state is not yet in the mood to do so. So there's two cases in Utah. And in Oklahoma, the Bishop case had been pending for almost a decade, just sitting there with a summary judgment pending. And the judge there, I guess, was inspired by the decision out of Utah and some other rulings, and issued a case that Oklahoma's marriage restriction is also unconstitutional. So there's two cases in the 10th Circuit. And there are cases in Arizona, Idaho, and Oregon that are also in the 9th Circuit that now I imagine we'll see briefings citing the GSK case, saying that heightened scrutiny should apply to equal protection claims within the 9th Circuit. So things are awfully exciting in the 9th Circuit as well. Let me flag that the DOMA decision, the Windsor decision, was about Section 3 of the federal statute, the Federal Defense of Marriage Act. There's also a Section 2 that pertains to full faith and credit and interstate recognition of marriages. Many of us think that is probably not the framing on which these interstate issues are going to be decided, because we have this quite robust, complicated area of conflict of laws to deal with family relationships and marriages in particular. Those disputes, states have disagreed about marriage ever since states had rules about marriage. And while this is all very exciting, many of these issues are actually not new. And so probably they'll be decided based on equal protection, and the Section 2 issues may not even be resolved as a key part of these cases. But I do want to flag that because there's lots of interest in what the full faith and credit clause may or may not mean with respect to marriages, and often discussions get treated as if that's the main issue. And I think many of us think, we'll see what happens, but that probably it's more a matter of equal protection. And specifically, why would a state, say, like Texas, refuse to respect a valid marriage of a same-sex couple when they might well honor the marriage of an underage couple that married out of state and then came to Texas? Even a couple that left Texas to evade Texas's law, got married in a state that would allow them to marry, and then came back home. If Texas would respect that, what are the reasons? What are the legitimate or important or even compelling reasons that the state might have for denying respect for the same-sex couple's marriage? So lots of opportunity to anticipate how the field of family law may develop as we proceed. So let me pause here and invite Dean Chemerinsky to talk a little bit about what impact this is all having on legal education, the inclusion of LGBT issues within legal education, and more broadly the legal environment, especially here in Orange County, but more broadly than that too.
Sure, I'll just be real brief and then turn it back. I'll be real brief and then turn it back to you, and then we can take questions. I think that one of the very good things that's happened in legal education, say over the last decade, has been the recognition of the need to bring LGBT issues into the law school. Those of you who have been in law school in the last decade have certainly seen this. There are courses on sexual orientation in the law, but also issues with regard to sexual orientation come up in so many other classes, whether they're constitutional law classes, family law classes, and throughout the curriculum. And I think that this is a trend that only should and only can increase into the future. I think it's important to recognize that all of the focus on marriage should not obscure the many other issues regarding the LGBT community that need to be addressed. I think it was the right choice for so many reasons to devote the attention and litigation to marriage, but there's still no federal law that prohibits employment discrimination on the basis of sexual orientation. There's still no law in most states that prohibits employment discrimination on the basis of sexual orientation. So there's still so much to be done in that regard. We've both mentioned now the GlaxoSmithKline versus Abbott Labs case from yesterday. That's a question about whether or not prospective jurors can be excluded on the basis of sexual orientation. This is an issue that the Supreme Court's going to need to address, and hopefully will follow what the Ninth Circuit said yesterday. So I think when you ask me about legal education, there's the need to bring much more into law schools with regard to these issues throughout the curriculum and speakers, and not just with regard to the marriage issue. I think that there are going to be really hard questions that will have to be addressed by the legal system. One of them that we were talking about in our email is I think we're already starting to see those who are arguing based on free exercise of religion that they should not have to serve same-sex couples or be able to use their religion as a basis for sexual orientation discrimination. One of these cases involved a photographer in New Mexico who said that he didn't want to have to take photographs of a same-sex wedding. There's so many contexts in which people claim, well, my free exercise of religion is offended by having to deal with same-sex couples or recognize same-sex marriage and the like. My hope is that these claims won't get very far. I'm not optimistic in terms of how the court might deal with some of them, but I think what we should do here is look to other claims of discrimination and whether or not free exercise of religion would be accepted as a basis for discrimination in those contexts. Would we allow a photographer to say, my business won't serve African American couples or interracial couples because it's against my religion to take photographs to have interracial marriage. We would say there that stopping discrimination is a compelling government interest. We don't allow employers to discriminate with regard to hiring or promotion, even if their religion requires it, or they believe their religion requires it, based on race or gender, nor should it be on the basis of sexual orientation. But if you focus on where is there going to be a wave of litigation to come, I think that's going to be there. Finally, I would just say there's no doubt that the Supreme Court's going to have to return to the issue of whether or not state laws that prohibit or refuse to recognize same-sex marriage are constitutional. It's not going to be this term of the Supreme Court. The docket for this year is set, and there's no such case. My guess is it will be next year, and if not then, certainly the year after. Maybe the Nevada case, maybe the Utah case, maybe the Oklahoma case. There's also soon to be, I think, rulings in Pennsylvania and Michigan and the other states you mentioned. I'm always reluctant to make predictions about what the Supreme Court's going to do. I long ago learned that he who lives by the crystal ball has to learn to eat ground glass. But here I'll make a prediction. I think that the Supreme Court will actually do what Justice Scalia predicted. I think that the Supreme Court will say that state laws that prohibit same-sex marriage deny equal protection. And I have a simple basis for offering that optimistic prediction. I think for Justice Kennedy, as well as for Justice Ginsburg, Breyer, Sotomayor, and Kagan, they have to ask themselves, do they want to write the next Plessy versus Ferguson, or do they want to write the next Brown versus Board of Education? There's no doubt where the country is going on this issue. There's no doubt where most of the world is going on this issue. And these are justices who want to be on the right side of history. Anthony Kennedy taught constitutional law for many years at McGeorge Law School. As he thinks about future professors of constitutional law, does he want to write the opinion that says that there's some legitimate government purpose for denying same-sex marriage, one that he knows that will be regarded with disdain in the future? Or does he want to write the opinion that's going to be celebrated? I think he will regard his most long-lasting legacy on the court to how he's advanced gay and lesbian rights in Romer versus Evans, Lawrence versus Texas, United States versus Windsor, in the next case to come. And so I think it's just a matter of time before the Supreme Court finds that there is a constitutional right for same-sex couples to marry, to equal protection, and maybe also an unfunded right to marry.
So, speaking of the Supreme Court and the role of religious liberty claims, I couldn't agree more that an existing and growing chapter of our work has been to engage the public in conversation about why we should have the same rule with respect to same-sex couples and LGBT people more generally that we have come to have with respect to other kinds of discrimination. Religious liberty claims were made by segregationists who, for purposes of public accommodation, as well as in defense of rules against interracial marriage. And religious liberty arguments were made for why employers who had religious views about gender roles should, for example, not have to provide health benefits to working women if their view was that men should be providing for the family and women should really be at home taking care of kids. And if they were working, well, maybe they would be paid, but they certainly shouldn't be receiving benefits for a husband who was staying home. And the courts have rightly rejected those arguments. We are at an interesting moment. I feel it's appropriate to mention in this context that today is the 41st anniversary of the Roe versus Wade decision. I'm very glad to be here and not in Washington, D.C., where some people are marching and protesting in sort of both sides of that issue, and it's really cold there. It's very nice to be here. But it's not as if 41 years later, the issue of reproductive freedom and women's autonomy and personal choices in medical care is a respected, settled issue. It's certainly not. And so I couldn't agree more that whatever the Supreme Court decides about marriage for same-sex couples within the next couple of years, there's an enormous amount yet to do, and including the conversation about what it means for everybody to have autonomy and liberty and what we mean when we say we respect religious freedom, but generally it's not religious freedom to impose on other people. I don't know if it's an irony or what it is exactly, but we are right now working on a friend of the court brief to the U.S. Supreme Court in the cases that were accepted challenging the Affordable Care Act's requirement that contraception be included within basic health care services that has been challenged by, we think we have a lot of marriage cases. There's a lot of cases challenging the contraception coverage requirement. Many of them, a great many of them, by for-profit companies where the owners have personal views about contraception and want to sort of line item veto the contraception coverage out of the health care plan provided to their employees. And it is at an interesting moment in history, at least I think it's interesting, that we're doing a brief about the needs of same-sex couples and the way these arguments affect same-sex couples, in part out of a sense that might help Justice Kennedy think about the issue of religious freedom and its why we respect it and its limits, because he may see that a bit more. I guess I'm showing my perspective on this a bit more clearly in the context of what it might mean and does mean for same-sex couples than might be the case with respect to contraception coverage, given the way the doctrine has evolved about women's rights in the reproductive health area. That's a very different situation than we had a couple of decades ago. But it's the issues are certainly very connected doctrinally, even though it's relatively recent that they have been more connected, I think, in people's minds politically. So let me cover a couple of the areas, sort of a shift from the Supreme Court and from religion and from lots of things to a couple of the things I would encourage you all to think about in terms of the impact of the Windsor decision on employment rights and so forth. Although I guess I could have deftly made a segue by saying that the issues of the religious freedom rights of some employees with respect to their coworkers and the limits on religious proselytizing in the workplace is actually something that has been quite important to LGBT employees, and it is important for employers to know that the duty under Title VII to accommodate religion of employees has not been understood by the courts as a duty to permit employees to harass each other or proselytize one to the other in ways that create a hostile environment for lesbian and gay employees or any other employee. And that issue comes up actually with more frequency than you might think, of employers trying to do the right thing and trying to accommodate the rights of everybody and sometimes being confused, but we do have some fairly clear case law, and specifically from the Ninth Circuit on that point. The areas that I want to flag are really maybe three different categories. So one is just the shift in attitude. I've already mentioned that, but there's a headline that I would commend to you. Lawfuel.com. I hadn't heard of it, but the headline is "Anti-Gay Clients Toxic for Some Law Firms." And it's just it's another interesting moment where the author is pointing out that the lawyer who's been hired by the state of Utah to defend Utah's law left Winston & Strawn in order to take on that contract. Winston & Strawn has been very supportive of its LGBT employees and civil rights work for LGBT people. And I don't know what their internal discussions were, but I think it's notable that that work is not being done under a Winston & Strawn letterhead, in a way similar to Paul Clement leaving King & Spalding to work for the Bipartisan Legal Advisory Group to defend the federal DOMA, and he joined a different law firm. I don't mean to suggest that two examples cover a whole field, but I think it does represent a shift, and certainly to some of us, I think that's it's an important sign to the LGBT attorneys and staff of any of those firms that the firm is really representing equality for everybody, and that's an important value when they consider either paid work or pro bono work. In terms of the treatment and the compensation of employees by firms, The areas where this comes up probably most notably are with respect to health insurance no longer being considered taxable income if provided to a same-sex spouse. And this is something that was of real concern to to many people who had domestic partner benefits or benefits for a civil union partner or a same-sex spouse. The change in law applies to a spouse. It doesn't automatically provide that same kind of tax treatment to domestic partner benefits. But because this is now a federal rule, it does mean regardless of where an employee lives, if they're validly married in a state that permits them to marry a same-sex partner, then the IRS, for purposes of federal income tax, will consider the health insurance non-taxable. The flip side of that, that's not an employment benefit particularly, but is relevant to some people, is that for purposes of federally insured student loans, the federal government is now going to recognize the income of same-sex parents or the income of a same-sex spouse of a student who's applying for a loan. So if you hear a rumbling noise over here, it's the gay and lesbian parents who are now unhappy that income of both parents is being recognized for purposes of their kids who are now applying to college. There are some things law firms have done and other companies as well to communicate support to LGBT employees, or I should say maybe LGB employees, and that's grossing up. Folks may be familiar with this term, and that was a matter of paying some extra to cover the cost of the federal tax. That was so that the overall treatment was going to be the same, and so that's no longer necessary on behalf of employees who have a same-sex spouse. It would be necessary for people who are in domestic partnership or civil union who aren't recognized by the federal government. And then I guess the main principle I want to just mention is that this does go across the range of different different employee benefits. So for purposes of COBRA, for example, a federal law that requires that an employee, when they leave employment, can continue to get health insurance through the company plan, that it has been permitted that an employer could allow that for a same-sex partner, but didn't have to under federal law. Well, if it's a same-sex spouse, then the same COBRA protection would apply. Same for flexible spending accounts. Anything having to do with federal income tax, where there's a preferential treatment for a spousal relationship, would now apply. Another big issue that I just want to flag for people, immigration, federal law, state law isn't particularly relevant there. There's a uniform federal rule at this point. So for purposes of employment, adjusting immigration status of a foreign-born spouse or a foreign-born worker who has a U.S. spouse, those processes should be considerably easier. I'm not going to get into details. It's highly specialized. But it is a big issue for folks where you have binational couples and a company is concerned about that relationship being able to be respected. I guess the last place I want to pause is not so much about DOMA, but it's the bigger landscape. As Erwin said, we don't yet have explicit federal employment protection for LGBT people. However, and we have the Employment Non-Discrimination Act, the bill that has been pending in more or less the same form since 1993, first introduced in 73, so it's really getting, well, it's not dusty exactly, but it's been pending for a long time, but it hasn't passed. However, Title VII has been interpreted by some courts and by the EEOC as covering gender identity discrimination, including an employee who transitions, that's sex discrimination. It's already covered. And there is development in a similar direction with respect to sexual orientation. We don't yet have cases saying that. But for those of you who counsel employers or for your role as an employer, it is an important trend to notice. The academics have been saying this forever, and the EEOC has now issued some decisions that basically recognize that it is sex discrimination if the employer is discriminating because an employee is having a relationship with somebody of the same sex, where if their sex were different, that relationship would raise no eyebrows. In other words, sexual orientation is based on sex, and the cases saying otherwise didn't really make sense. They didn't have logic. There's a lot of them, but it doesn't really make sense. So be aware of that, because I think that the courts are going to be going in that direction, and it's much easier for employers to be able to pass along that guidance or to put that understanding behind existing company policies if you have folks who engage in harassment or otherwise, might be acting otherwise. It's a good liability protection to be aware that the law is going that direction, even though ENDA hasn't yet passed.
We have about 5 minutes. We have about 5 minutes left for questions in our hour.
We have a microphone over there, and then I've got one here.
Never really need a microphone. I'm just wondering, with respect to the employment issues, how do you suggest we advise our clients, our employer clients? Because some of them don't want to hear what the law is going to be or what the trends are. They want to know what's the bright line test for them today.
Yeah, so I would say that as of now, Title VII has been interpreted by the 11th Circuit, by the EEOC, and by some of the other circuits in less authoritative language to cover gender identity discrimination. And so that means it's quite sensible for employers to develop policies about things like, if an employee comes and says they're going to transition, to make a plan and manage that. And there are folks with, this is not new, and the ways to manage that are known. Information is available. We're happy to be a resource, but there are people who specialize in providing that kind of guidance to employers so that the situation is managed proactively, both because it's the way to, it's the way to have everybody feel comfortable so you don't lose your good people and, you don't end up with a lawsuit.
In California law.
And California law has covered sexual orientation for a long time, and so is the law. It's about half the states have sexual orientation protections in state law, and somewhat fewer have gender identity protection in state law. Although again, all the states have sex discrimination protections, and we have that at the federal level. And I think the other idea, and I think it is coming up. In particular, in states that are more conservative, that have state laws against recognizing marriages of same-sex couples, that many people are feeling pressured and are not happy about that and are thinking, and the Supreme Court any minute is going to tell us we have to recognize these gay couples and we don't want to. And I do think it's the role of lawyers to encourage some proactive grappling with that. And certainly on the employment side, in some places with respect to sexual orientation, there's not a state law, there's not clear federal law. There often is a company policy, and there's a growing social expectation that in particular with respect to harassment, upward of 80%, according to national polls, of Americans think people shouldn't be denied a job based on their sexual orientation. That hasn't yet persuaded John Boehner to call the bill for a vote, but I think in terms of the practical advice, in many places there will be liability, in other places there will just be a dispute, and it just doesn't really make sense anymore to say that this is fine. I hear you that people want a bright line, and I guess part of what I want to impart is, I can tell you which direction it's going. And based on the number of cases that have been filed on marriage just recently, which used to be such a big, scary issue, the line is moving pretty quickly. So whatever happens today may lead to a lawsuit in, a year or two, and the law may well be that much clearer at the point that the case would be filed. So the smart thing to do is to deter that conduct.
Anyone else? Any other questions?
There are many ways in which the LGBT rights movement has looked to other civil rights movements, both in the past and currently, whether that's racial justice or women's rights. I'm kind of curious about your thoughts on what some of the differences are, specifically how cause lawyers in the movement and the courts are grappling with issues that are very distinctive and unique to sexual orientation. I'm specifically interested in how the Ninth Circuit case came to its conclusion that there's a heightened level of scrutiny for sexual orientation.
Well, so we should have a whole nother session on that, which is a great combination of questions. So I would say, first of all, I invite everybody to read the GSK decision, and that will that's a sort of a sneaky or a cheap way of saying, well, your good answer is right there because Judge Reinhardt explained it. Many of us we've been briefing that issue forever. And the Ninth Circuit had ruled back in 1990 in a case called High-Tech Gaze that it's only rational basis review. And that was before the Supreme Court had ruled in the Lawrence case, and so it relied on the old mid-'80s Bowers versus Hardwick decision, and sort of said, how can there be heightened protection for a group that can be criminalized? It makes no sense, even though one doctrine was about privacy and autonomy and the other is equal protection. They really are different, but High-Tech Gaze had sort of been in the way in the Ninth Circuit, and we've been briefing it. The scholars have run out of ink writing that, if you just apply the test, you can't really have any serious question about that all of those elements are satisfied with respect to sexual orientation classifications, which, by the way, doesn't just mean gay people get something special. It's that, whatever a person's sexual orientation is, gay, straight, bi, whatever, that's not an appropriate grounds for government to be making a distinction unless there's an awfully damn good reason for doing so, which, so far I haven't heard of any, but whatever. So I think it had been not so much that the analysis wasn't persuasive, but this mood that had kind of developed among some people, well, the Supreme Court just isn't going to do this anymore. And in fact, that's the main theme of the brief filed by Nevada, which was filed the same day that the decision came down, saying the Supreme Court just isn't in the business of doing this anymore. Well, that's not a legal argument. So we could have more discussion about that. I do want one or two things about the similarities and differences among movements. One way to capture this, in my mind, there's many things to be said, and so for some of us, the difficulty or the difference between eliminating de jure discrimination and day-to-day lived de facto discrimination, this is the huge problem that the racial justice movements are grappling with. And I see it as a big, blinking, important neon cautionary sign that with any movement, it's easier to rally people around an explicit discrimination than to deal with the embedded systems of who has resources, who has power, who creates opportunity, people hiring people that look like them, and all of that. That's very difficult. The LGBT movement has perhaps a benefit of we're everywhere. We're in every community. We're in most families, if people are honest with each other. And so there's we can have different kinds of communications, and there's the power of relationships that does make it quite different. There's lots of similarities, lots of differences. It does come up some in the conversations we have about drafting legislation and whether it's appropriate to say, in order to have people calm down and be supportive, or in particular white people, oh, this bill doesn't involve affirmative action. And I am frequently in the role of saying, let's be very careful about adopting language that's very vague and is a lot about knee-jerk reactions and political organizing. Many LGBT people don't need affirmative action per se because often we already are in jobs. We were just closeted. And it's more about holding on to jobs and not being harassed than it is breaking down the doors based on people being recognized as they're sitting in an applicant chair. But the term means a lot of different things, and it means remedies often that are quite appropriate. And these movements are very connected. Certainly if we're seeking to add sexual orientation or gender identity to an existing civil rights framework, we better not go changing things that affect everybody, because the movements are connected, and equality lawyering is very connected as well.
Let me take 1 minute, because then I know we're out of time. I agree with everything that Jenny said. I think there's been some real differences in the strategy of litigation. When it came to race especially, but also to gender, the view was that it had to be brought in federal court. There was no chance of getting an elected southern state judge to find laws that required segregation to be unconstitutional. It's interesting, the initial choice with regard to marriage equality litigation was to go to state courts and to not present a federal claim so it couldn't be removed to federal court because the belief was it just wasn't time to get this to the Supreme Court. So the litigation in Massachusetts, which was the first state to recognize this, or even before that in Hawaii, in Bear versus Lewin, in New York where it wasn't successful, in Iowa where it was, in California where it was successful, but to try to keep this in state court on state law grounds, that's quite different than the litigation that occurred with regard to race and with regard to gender. I think what changed that a great deal is when Ted Olson and David Boies, for better or worse, decided to bring a federal court lawsuit in California to challenge Prop 8. And I think that the ability of the movement lawyers to control the lawsuits just was gone at that point. And so now you have an enormous number of suits in federal court as well as in state court. But I wanted to point to that difference for us as lawyers. I think, though, that the basic underlying theme of the litigation and of the movements is very much the same. It's all about human decency and the respect for the dignity of the individual. And if you think what was the racial equality litigation about, or the gender equality litigation about, or now the litigation on behalf of LGBT community, it's really about respect for the decency of each individual and respect for dignity. That's why I think Justice Kennedy's language about New York giving dignity and respect to the marriage of Windsor and Spire is so important, because that's what all of this shares in common.
You know, some people have pointed out that it's awfully interesting that Justice Kennedy talks so much about dignity as somebody who was raised Catholic as he was and actually worked as a lobbyist for the Catholic Church for a while in the early days of his career, that the concept of dignity is so important to him. And that it's dignity and respect and less about rights and defining the exact parameters of what the rights are. I mean, his jurisprudence is different from the dominant jurisprudence of a couple of decades ago. And I do want to, I guess, flag that. So at the point that the movement for racial desegregation was happening, I mean, you had a significant part of the country that had segregation and a significant part of the country that didn't. With respect to marriage for same-sex couples, well, we didn't have that right anywhere. And it was sort of a matter of trying to engage the conversation, engage the country in that conversation in the shadow of the Bowers versus Hardwick decision from the U.S. Supreme Court, the majority decision in which was about the farthest you could come from dignity and respect for gay people, sort of saying the claim for dignity and respect was deemed by the majority opinion to be facetious, at best facetious. So, I mean, I feel like, many of us learned and think of our jobs in terms of representing a community of people so much shaped by what seems to have been important in the movements that we studied as students. And among the biggest challenges is thinking always about what's changing. And, when do we need to be doing something different because the conditions are different? And which things do we think we can control, or at least we should try, and which things we can't, and we should just be gracious about it and do what we can do, and, recognize that it's a movement and nobody has a monopoly on good ideas. And we are a movement that has an awful lot of contrarians. I mean, many people would never come out if they were good at following rules and listening to authority. So we can't really then be surprised if we have a lot of independent-minded people who want to do their own thing. And we have a choice to think of it as a blessing because it's a movement with a lot of energy and an awful lot of allies. And I do think about the amount of support, the resources, and the work done by people who now count themselves as allies, as that's why we're succeeding. I mean, Ted Olson may be the most dramatic example of that, but it really is a movement of an awful lot of people. Since we probably number at most about 3.8% of the population, well, we need allies, and it's a wonderful thing that we these days have so many.
Thank you very much. Just a couple of very quick housekeeping things. There's a form that's available to do an evaluation, which would be appreciated. There's also handouts that they reference that are there, and then parking validation for those that weren't able to get it there. we have parking validation right there. Yes, may leave them.
And if you
Thank you again very much,
didn't
and thank
sign
you,
in,
Dean Chemerinsky and Jenny Pizer, very much.
sign in for CLE credit if you didn't sign in.
Wonderful. I hope we get to do this again. We can do it a lot.
Thank you so much.
Good to see you. Thank you.
How are you?
Do you know Jenny?
I actually don't. I'm Tom Phelps. This was a very good program. Yes, but so are you. I mean, I noticed neither one of you was hooked on your text. I mean, it was very impressive.
Seen him never even a 4x6 car.
That's right. Well, he practices before the mirror every morning. Anyway, thank you. Yes, Manette, yes, exactly. Yeah. I'm Phelps of Manette. And yes, I'm mostly